Let's talk about equal protection under the 14th Amendment to the U.S. Constitution. The first thing that you should know is that criminal laws may discriminate based on various factors. So, for example, if you're 20, you can't drink alcohol legally. If you're 21, you can. So that's a discrimination of two different groups of people based on their ages. Okay? So it is permissible to discriminate under certain circumstances. And what we're about to talk about is when it's okay and when it's not, when it's constitutional and when it's not, all right? So there are three levels of scrutiny. There's rational basis for non-suspect classes of people. So for people who have not been traditionally discriminated against, for example, like 20-year-olds, like we just talked about, the standard is rational basis. If the state writes a law that says if you can't drink alcohol until you're 21, that law will be presumed valid by the U.S. Supreme Court if it's rationally related to a legitimate state interest. So the state's interest might be making sure that young people don't hurt themselves when their judgment isn't fully formed, right? Next, we go to intermediate scrutiny. So intermediate scrutiny applies to what the court calls quasi-suspect classes of people. And so an example of that, and really the biggest example, is gender. So gender-based discrimination, say for example, and there have been cases on this, a law that says that a woman can't walk topless down this path in a state park, but a man can. Well, that's discrimination between men and women, right? It's a different law, applies to the two different groups, and it's based on gender. So that's gonna be held to intermediate scrutiny. So the court's gonna say, is it substantially related? Notice the stronger language. Rationally related just means, does it have something to do with it? Okay? Substantially related, speaks for itself. It's much stronger language to an important state objective. Again, stronger language. A legitimate state interest, going back to rational basis, is just something that the state legitimately has some interest in, okay? But an important state objective has to be something that's, again, at this level, it speaks for itself. That's important, right? So the notion there with the topless ordinance would be that there's some moral code that's being offended when if women are topless in this park that I've been talking about, okay? So that's intermediate scrutiny. Then we go to the highest level. The highest level is strict scrutiny for suspect classes. And here, the distinction, if you're going to break it up between classes, it has to be strictly necessary with no alternative, so there's no other way you can do this, to advancing a compelling state interest, so something that's really, really important, all right? Otherwise, you can't do it. And here, it's with regard to race, ethnicity, and fundamental rights. In the modern era, I don't think you're going to be seeing any laws that are written based on race or ethnicity, okay? But fundamental rights, you will. And a good example of that is the right to bear arms, because frankly, that's only recently been ruled to be fundamental, and there is a strong desire to write laws about this, to control how people exercise that right. So it's a fundamental right, and it will be held to a strict scrutiny level, laws that are written with regard to that. So I hope that explains for you the Equal Protection Clause and the three levels of scrutiny that the court uses when it examines laws to say, is this law constitutional or should it be struck down?